Hi, good evening. This is a Delhi High Court judgment on customs valuation under section 17(5). Very, very important judgment and interesting judgment. The citation is Neeraj Silk Mills versus Commissioner of Customs. So, if you are a importer or an exporter, you may be knowing the customs procedure, but slightly I will touch upon that. In this case, importer has imported certain goods. Do not worry about the nature of goods. Some goods have been imported. They filed their bill of entry. Revenue disputed the declared value on the basis of contemporaneous import data. It is a national import database. That is the basis on which they have rejected the declared value. The customs authorities, as usual, exercising their power, they were not permitting clearance of goods. So goods were inordinately delayed. So the importer, he was compelled to pay the differential duty on enhanced value. They said, sir, we will pay the value whatever you are saying. Please permit us to clear the goods. Otherwise, we'll be incurring demurrage or warehouse charges. Please permit us to clear the goods. So then the case of the petitioner was this was done because of the compulsion and coercion by the customs authorities. It was not voluntary. So this is the case of the petitioner. Then the post bill of entry being reassessed, the importer filed appeal before the Commissioner Appeals. Commissioner Appeals held that mere clearance of goods at a higher value, it will not deprive the right to institute appeal. That is what the Commissioner Appeals held. Secondly, he said, the Commissioner Appeals said, NIDB data, that is National Import Database, that alone cannot be the basis for enhancing the declared value of the imports. On this reasoning, the Commissioner Appeals allowed the case in favor of the importer. Then the department went in appeal to the CSTAT. CSTAT held that once the importer has paid duty, if the importer has paid duty on the enhanced value and waived the right of adjudication, then the importer cannot challenge the reassessment. On three reasonings. The reasoning of CSTAT was three. One, the importer consented value to the declared value. Then it becomes the declared transaction value. Two, if importer accepts enhancement of value without protest, he cannot be permitted to deny its correctness. So once you have accepted, then you cannot deny the correctness of that value, enhanced value. Three, the burden on department is discharged if enhanced value is voluntarily accepted by the importer. On these three grounds, CSTAT reversed the order of the Commissioner of Appeals. It held in favor of the revenue. Now, this was challenged before the Delhi High Court. Delhi High Court, it made into four compartments. Whatever is what the issues. First issue is declared value and power of reassessment or reappraisal, whatever it is. So I have already said this thing procedure for filing bill of entry and clearance of goods. So normally what happens is you self-assess the duty. Again, I am reiterating just for the purpose of understanding. Importer has to self-assess the duty. He has to file a bill of entry containing a declaration that it should be filed electronically. Invoice also to be submitted. Officer has to pass the order permitting clearance for home consumption or warehousing. Once the bill of entry is submitted, if the proper officer examines that bill of entry and accepts the value, then it is deemed to have been assessed. In that case, there is no list, there is no dispute. In that case, no speaking order is required to be passed. Order of self assessment is an order of assessment, and any person aggrieved may file an appeal. That is also the basis for the filing appeal. The power to reassess is triggered. This is very important. The power to reassess is triggered only when, in the course of verification, officer forms an opinion the self assessment was done incorrectly. So, officer he examines the bill of entry, then he comes to the conclusion, he entertains a doubt that this value has been declared incorrectly. Under the reassessment, I'm sorry, unless the reassessment is accepted by the importer in writing, the officer is obliged to pass a speaking order. So, in case if the importer is not accepting the value declared by the enhanced by the officer, then the officer has to pass a speaking order. For reassessment, the proper officer has to first form a prima facie opinion that the self assessment is incorrect. Formation of opinion is guided by Customs Valuation 2007 rules. As per Rule 12, the sine qua non for commencing reassessment is existence of reasonable doubt as to the declaration made by the importer. That is the value. Based on reasonable doubt, the officer can verify the accuracy of the declarations. Then, officer can reject the value and proceed to determine the value, exact value, declared value, or you can enhance the value. Rule 12.2 states, at the request of the importer, proper officer is liable to disclose the reasons for his doubts on accuracy. He should also give a reasonable opportunity before taking any decision. Delhi High Court held on a reading of section 17A, 17.5, read with Rule 12, the formation of opinion that declaration is incorrect, that must exist. That is the first point. First, officer has to form an opinion that the declaration is incorrect. That must exist. The second one is that should be recorded. It is not enough, sir, I entertain a doubt. You must record the doubt. What the reason? Guidance for officer is given under explanation rule 12.2 A to F. It says what are the circumstances on which the officer can entertain the doubt. I am not going to say what it says A to F. If you want, you take the act book and see. Reasonable doubt which can be harbored is not left to the whims and caprices of the officer, because rule specifies it. Court held that doubt can be entertained with regard to accuracy of declared value cannot be the outcome of uncanalized or capricious exercise of power. So just on the drop of a hat, the officer cannot say, no, no, sir, I don't accept the value. But that is the normal way in which the customs authorities behave. I have personally dealt with the customs authorities. I am sorry to say this, even though I have great respect for many of the officers, at least some of the officers, they think they are above the law. That also I record here because I personally had personal experiences there. Then next, the obligation to provide reasons and opportunity to importer is mandatory under section 12.2. That is what the court says. Both section 17 and rule 12 are liable to be interpreted mandatorily, requiring reasons for doubt. Otherwise, it would lead to arbitrary exercise of power. This is what the court says. The next sentence is very important. The consent or concession of importer cannot be construed as relieving the officer from documenting the reasons which formed the basis for doubting the declared value. This is excellent. This, please note again, I repeat again. The consent or concession of importer cannot be construed as relieving the officer from documenting the reasons which formed the basis for doubting the declared value. Otherwise, the court says, it is impossible to judge whether the decision of officer was fair, reasonable, and valid in law. The court also may not be able to discharge its constitutional obligations, that is, judicial review. Once an opinion is formed, unless that opinion is recorded, how will the court know what is the reason, what is the based on which this opinion was taken? Otherwise, court will not be able to judicially review that opinion. That is what the court says. High Court relied on a Supreme Court observations stating that mandate of Rule 12.2 can neither be ignored nor waived. These are all very, very important. Supreme Court held that when a request is made, there is a statutory obligation on the officer to intimate the importer the goods on which the doubt is the grounds on which the doubt is founded. So, if the request is made, officer must furnish the grounds on which the doubt was entertained. Supreme Court also deprecated the insistence of officers compelling the importer to disclaim or forego statutory right which the act confers. This is again very, very important. Again, I repeat. Supreme Court deprecated the insistence. The High Court is relying on several Supreme Court judgments. In one of the judgments, Supreme Court deprecates the insistence of officers compelling importer to disclaim or forego statutory right which the Act confers. Even though Act gives this power, you can ask for the grounds on which you are entertaining doubt. The officers are complaining, no, you write and give, otherwise I will not release the goods. This should not be done. That is what Supreme Court says. Finally, Delhi High Court concludes that neither the opportunity of questioning an opinion with respect to reassessment nor an opportunity of hearing can be waived. The procedure is mandatory. This is what the Delhi High Court says. Second issue, abandonment and waiver. CSTAT held the exchange of communications would amount to waiver or abandonment, not just the right to question the reassessment, but also impugn it in further proceedings. Again, this issue is very, very important. Please note. CSTAT says in its order favoring the revenue that the uh, waiver or abandonment, it will not be just the right to question the reassessment, but also impugn the order in further proceedings. This is what CSAT says. Delhi High Court held the right to question the decision of the officer, whether it is formation of the opinion or even on merits, is protected by statute. It relies on another Supreme Court judgment in Shah Mulchand. Supreme Court held abandonment would have to be more than mere waiver, acquiescence, or laches. Delhi High Court Delhi High Court says it perused. First, it perused the letters submitted by the importers to the authorities, and then it says, based on those letters, that letters submitted by the importers state without prejudice to. That is the most of the letters will contain this without prejudice to. That it is there. Secondly, they were submitted for expeditious clearance of goods. The letter itself, because they have extracted a few letters in the judgment itself, maybe 5, 6 letters. In all the letters, it clearly says we are accepting the value for expeditious clearance of goods, and it also says without prejudice to. This has been noted by the Delhi High Court. The Delhi High Court says, the same cannot be viewed as an abandonment of right to institute appeal itself. The Delhi High Court says CSTAT failed to look into the communications submitted by the importers, and the CSTAT automatically presumed they have submitted letter. That means you have waived everything. This is what the CSTAT assumed, which is incorrect. That is what the Delhi High Court says. Then third, rejection of declared value. This is also very important. This is the third heading. Delhi High Court held that there was failure on the part of the officer to communicate reasons based on which doubts were entertained with respect to declared value. Point number one. Point number two, contemporaneous data was NIDB data. That is what I first said. National Import Database. Based on that only the declared value was rejected. That is the only basis. That cannot be a standalone basis to doubt the declared value. That is point number two. Three, importer paid duty under protest. That is also recorded in the letters. We are paying duty under protest. It was there. So that has been noticed by the Delhi High Court. Four, the burden of proving incorrect valuation is on the department. This is also very, very important point. The burden of proving incorrect valuation is on department. Before rejecting the value, department has to prove with cogent reasons based on invoices, inquiry, investigations, everything. They have to prove that the declared value is incorrect. Then only the burden will shift to the assessee, the taxpayer, or the importer. Supreme Court in a decision, again one more decision, held that without adequate evidence or comparable data, declared invoice value must be accepted. This is a Supreme Court judgment. So if the customs authorities are not conducting proper inquiry, verification, investigation, but simply rejecting the invoice value, then Supreme Court says, in that case, without adequate evidence or comparable data, declared invoice value must be accepted and benefit of doubt should be given to the importer. This is what the High Court says based on the declared value. Rejection of how the authorities can reject the declared value. Then the final one is value based on enhancement of NIDB data. That is the fourth thing the High Court deals. High Court has seen many CSTAT judgments and many Chennai tribunal or other tribunals, CSTAT tribunals have held that consistently, that too consistently held that the declared value cannot be rejected solely based on NIDB data. I don't know how the CSTAT came to this conclusion that the enhanced value based on NIDB data that can be accepted. I don't know how this tribunal came to the conclusion in spite of several judgments of the CSTAT saying that NIDB data, standalone data, cannot be accepted. So on that ground also, the Delhi High Court said that the judgment of the CSTAT is not acceptable. So the entire order of the CSTAT was set aside by the Delhi High Court and it was in favor of the importers. So thank you very much. Have a great evening. Bye.